informational purposes only. We are here today to talk about an order that came from the federal government in September of last year, and it has been extended. The latest extension was on December 21st, 2020, when Congress released the much anticipated legislation for the coronavirus emergency relief package. We want to have an open dialogue about that package, about the CDC moratorium that came out of that package and what it means for immigrants in North Carolina. The sad narrative across the United States is that immigrants are most at risk of getting kicked out of a home or apartment because of their jobs, are more likely to be eliminated, and they are at greater and higher risk for financial insecurity. And so we are so excited to be having this discussion today. We're excited to have two amazing panelists who have agreed on a very short notice to have this discussion with us today. They'll be leading these sessions. First, we have Rebekah Niblock. She's an attorney in the Immigrant Justice Program at the Charlotte Center for Legal Advocacy. Before joining Charlotte Center for Legal Advocacy, Niblock worked for 4.5 years as a staff attorney with the Immigration Project in Champaign, Illinois, and she taught as an adjunct professor with the University of Illinois College of Law's Domestic Violence Immigration Clinic. Niblock also earned her JD from the George Washington University School of Law and her Bachelor of Arts in Romance Languages and International Relations from the University of North Carolina right here in Chapel Hill. We also have with us today Juan Hernandez. Juan is an attorney in the Immigration Justice Program. Hernandez taught high school math at Roosevelt High School in St. Louis, Missouri, through the Teach for America program for 2 years prior to attending law school. Hernandez began his legal career prosecuting criminal offenders in St. Louis, Missouri, where he developed his skills as a litigator through a first-chair experience in numerous jury and bench trials. Hernandez has earned his JD degree from St. Louis University School of Law after earning his Bachelor of Arts degree from the University of North Carolina at Chapel Hill as well. And so before I turn the session over to our panelists, I want to thank our funder, Blueprint, for sponsoring this session and for granting funds for Disability Rights North Carolina to do this important outreach and help us get this information out into the communities across the state. And so now I'm going to turn it over to Rebekah and Juan to have a more in-depth discussion about what the CDC moratorium mean for our immigrant population. So Rebekah and Juan, turning it over to you now.
Thanks, Iris, and thanks for having us. And I look forward to kind of having an open discussion with everybody here. So as questions come up, feel free to just interrupt me. We're more than happy to work around a conversation as opposed to just a pure presentation. So one of the things that I'm going to talk about first is what is the CDC moratorium? There's a mixture of different levels of understanding of it on this call is my understanding. So I want to go over that. I want to explain who's protected, what are the qualifications to receive this protection, and practically how to ensure that you are receiving that protection if you're a tenant. So presently the CDC Eviction Moratorium was extended through January 31st of this year. So what the CDC moratorium does is a tenant will receive protection and not be evicted for reason of failing to pay rent on time. During this period, the tenant cannot be physically evicted. So what we refer to that as the execution of a writ. So that's the process of the sheriff's department actually going out there and changing the locks on the door. So that can't happen during this eviction moratorium. So the hope is that President Biden will continue it. That remains to be seen until it happens, but let's hope that that continues because that has kept a lot of people in their homes and out of homelessness. So that's something that we hope to see shortly into the administration. So who qualifies to get this protection? And before we get to that, how do you establish this protection? So this protection is not automatic. The tenant has to physically hand a copy of the CDC affidavit. It's a declaration that's found on the CDC website. The tenant has to physically hand a copy of that to the landlord, to the property manager, etc., for that protection to be created. It's not automatic. The tenant has to do something, and that's one of the things that I want to talk about a little bit later on. It's very important for the tenant to have to assert this. It's almost a defense. It's not an offensive strategy. It's a defense that must be asserted. When this document is turned over to the landlord, theoretically the landlord will not move to evict this person through the term of the CDC moratorium. That's not always the case, and some landlords are better than others at following the law. So when I talk to my clients and tenants, I tell them, you know what, maybe you did this, maybe you submitted this affidavit, but that doesn't mean you can just ignore everything that happens from now until the end of the moratorium period. Tenants still have to be keep abreast of the situation. So who qualifies? So most importantly for us,
Hey, bitch.
Okay, be patient with us. We're trying to.
Accidente, voy a hablar en español.
Okay. Sorry about that, Juan. You can go ahead and proceed. I think we've taken care of it. Okay.
not a problem at all. So one of the most important things that I tell my tenants is, you know, there's obviously this fear of public charge and what that's going to affect you later on. If it's going to affect you, if maybe by the time that you're applying for change of status, that's gone. One of the most important things is if you feel like homelessness is on the horizon, you have to protect yourself and protect your family, and that long-term risk that public charge may pose, maybe that.
Vale, tío, me la subo. Joe Biden.
Long term, I think it's important to consider the benefit of using the CDC moratorium. Legal status is not considered at all. You can have status, you can be a DACA recipient, you can be a US citizen, you can be undocumented. That does not matter with regards to asserting the CDC moratorium protections. Anyone can assert them. What is important is that the person whose name is on the lease, that person is the person who should submit the signed declaration. If there's more than one person in the lease, thankfully in North Carolina, you only have to have one due to Governor Cooper's executive order. But if you're looking at other states, every person who is an adult who is responsible on the lease should sign a copy and submit it to the landlord. Status is not important in this analysis. The person just has to make less than $99,000 a year if they're filing single, or if they're married filing jointly, the two married people cannot make over $198,000. The person who is signing the declaration is declaring under oath certain things that they qualify, and some of the qualifications also include that they have used their best efforts to obtain available government assistance for rent or housing. Rebekah is going to talk about how that impacts the public charge rules. So what I have told my clients regarding what best efforts means is if the CARES Act money, which right now in Mecklenburg County is dried up, if in your area the application for that funding is still open and still available, I tell my clients that in order to really truthfully state that they have made their best efforts, that they should have applied for that. Right now in Mecklenburg County, there isn't any funding. So if because the affidavit states they've made their best efforts, because there's no financing available. Doing the research, trying to find what's out there, and being prepared for the next round of funding, I think that there's an argument to be made that they have made their best efforts to obtain available government funding relating to rent assistance. Practically, I've also told people to call 211, and when the HOPE application was open, I told them to call HOPE as well. The reason being is that a landlord can challenge in court whether someone is being truthful when they submitted their CDC declaration. And I tell people to take notes of what happened. HOPE would have emailed them or mailed them a letter. And if they have to go to court to prevent the eviction, and the landlord challenges the veracity of the CDC declaration that was given, they have physical, tangible proof of what they did in order to meet the qualifications for the CDC protections. Now, another qualification is that the person is unable to pay rent in full due to a layoff, hours being cut, or extraordinary medical expenses. So extraordinary medical expenses is being defined as 7.5% of the gross income for the year. One of the good things about this is that there is no direct tie to COVID in this. So if someone is, for example, suffering through diabetes or through cancer or through some sort of other ailment that is expensive to treat, and their expenses are greater than 7.5% of their gross income, they might still be able to qualify to use this CDC declaration, so long as they qualify otherwise. The tenant would also be stating that if they were to become evicted, they would become homeless, have to move into a shelter, or move into close quarters with numerous other people. So I've told people what this means is, yeah, you know what, your sister lives in a 2-bedroom apartment with her family, right? Well, that's 4 people. The 4 people that are in your family, if you become evicted and you have to move in with your sister, you know what, it keeps you out of homelessness and in some form of stable housing. But having 8 people in a 2-bedroom apartment that's maybe 800 square feet, that's a really enclosed space with a lot of interaction with people. And that's what the science tells us, and I'm not a scientist, but what I've read is that being in closed spaces with a lot of people is how we transmit this disease. And usually that tells someone that, or that convinces someone that, you know, maybe it does make sense to submit this affidavit. So what else does the declaration say? And you'll hear me say affidavit and declaration interchangeably. That's something that for whatever I do, it's something that I've kind of fallen into the habit of doing. So if you hear me say affidavit or declaration, I mean the same thing. What else does the CDC declaration say? It says that the tenant is making their best efforts to pay rent. So this is something that's going to come up with some of the stimulus payments that are going to come in. What I could see occurring is that a landlord will come in to challenge the CDC declaration and say, my tenant is behind on rent for $8,000. I know that they received the stimulus payment. In the cases of undocumented families, that this might not apply to us. But if for example the family does qualify for a stimulus payment, the landlord might come in and challenge why there has been no payment, and whether it is truthful that the tenant has made the best efforts to make payment on the rent, even partial payments. So that's something that I tell my clients to consider, so that they know that this debt is not forgiven, that they know that maybe rental assistance can come through, maybe it can't. And in the case that it can't, they have to start planning for how they're going to pay that rent, or a backup plan, which would be how they would find a new place to live.
Juan, can I stop you for one moment?
Please.
Okay, we have I think a question here in the chat box, but do we have anyone that can speak Spanish? I think that might be part of the question, is maybe an answer in Spanish, and I'm not sure of that. So I just wanted to check?
Yes, so I can explain that in Spanish. That's a big question. Es una pregunta grande. What I'll do is, that way Rebekah can make her presentation. At the end of, if this is okay with everyone, I would be happy to answer that question towards the end. That way we're sure that Rebekah is able to explain certain things.
Okay, thank you.
Yeah, no problem. And please, if you guys have questions, please feel free to put them in the chat or interrupt me. One other thing that I want to talk about is serving. I mentioned that you have to take this document to the landlord physically. So one of the things I tell my clients is make sure you have somebody go there with you. That way you have proof of service. Ideally, your landlord, you will have 2 copies, sign both copies, hand one to your landlord, and have your landlord write something on your copy that says received on blank date. The reason being is that way you have proof of service for the future, in case you have to go to court. So
in Spanish, please.
Sí, lo que voy a hacer es al fin de esta explicación voy a hablar en español para todos, ¿ok?
Okay, gracias.
De nada. In case that someone is undocumented, that they will not qualify for service through Legal Aid of North Carolina. Here in Charlotte Center for Legal Advocacy does represent individuals who are undocumented in eviction matters. And I would say in your communities, you know better than I do as to maybe there's some lawyers in the county bar who would be willing to assist. So maybe that's something if you are an advocate, maybe reaching out to places like that. I see a question, what can we do if the landlord doesn't want to sign the affidavit? So you don't need the landlord to sign the affidavit. It's just proof of service. So that's why if you have somebody else coming with you, that you have a second person to say, yeah, this actually was hand delivered, and the landlord can't then say in the future, oh, I never got it. Because what we're seeing is that landlords are still going to be able to, or still going to try to evict people. So that's why if people get court documents and they submitted the CDC affidavit, they still have to go to court, and they want to bring a copy with them. That way they can tell the judge, say, Judge, I submitted this on this day, I'm protected. And hopefully that would work. One thing I did want to mention is that our new Chief Justice Newby, permitted one of the emergency orders that required the landlords to submit a CARES Act affidavit. He permitted that emergency order to expire. The reason that hurts our tenants is because that affidavit required the landlord to state whether or not they had received a signed CDC declaration from the tenants. So that's a place where I disagree with the Chief Justice's action, because I do believe that that's going to allow for people to be evicted that wrongfully, that should stay in their homes. Regarding all cases filed before January 31st due to Governor Cooper's executive order, there should be no evictions for not being able to pay rent through the end of this month. Someone can be evicted for other reasons. For example, lease violations, unauthorized pet. What we found is even if the reason that's stated on the on the complaint is pretextual, and that unfortunately landlords have been able to move for evictions based on pretextual reasons.
I think you have a question in the chat asking about if figures have been given for evictions regarding Latinos.
I don't have data on Latinos specifically, actually. That's a good question. The last data that I received was for the eviction totals in the state of North Carolina through November 1. As of November 1, there were 18,000 open eviction cases. About a quarter of them are in Mecklenburg County. So that it's just a grand scale of this problem's on a vast scale. I would imagine the numbers are significantly higher today, but I'll need to get additional data on that. And I'll let Rebekah talk about, I mentioned that in order to qualify, someone has to make their best efforts to receive rent assistance. So Rebekah is going to talk about that rent assistance and whether that could potentially cause an issue for someone through the public charge analysis.
Hi, everyone. Thanks for inviting us to talk today. I'm going to talk a little bit about public charge. I don't know how familiar most of you are with public charge and immigration law. Before Donald Trump, his administration promulgated a new rule on public charge, some new regulations. It wasn't talked about very much, not even in the immigration world. It wasn't really a thing. But now it seems like even the general public has heard of public charge, and to a lot of people it sounds pretty scary. But today I'm just going to go through what it is, who it could affect, and what are some of the public benefits included in the public charge analysis. And we'll talk about a couple that aren't and how that relates to COVID and the pandemic and applying for benefits such as help with housing. So public charge is a ground of inadmissibility. So essentially, immigration looks at reasons a person can enter the country or become a legal permanent resident, and based on their history, such as their criminal history, and now the case of whether they've applied for public benefits in the past, immigration makes a decision whether to admit them as a legal permanent resident or not. So a non-citizen, the Trump administration essentially redefined what is a public charge and pretty much broadened the definition to affect more people, and more public benefits are included. So today the rule is defined as a non-citizen who receives one or more public benefits as defined in the rule, which we're going to go over a couple, for more than 12 months in total within any 36-month or 3-year period. And I really advise you, maybe I can put it in the chat box here. Let me just put it, the website to visit where I'm getting like all of the information. It's very helpful, uscis.gov. You can type in their search there, or USCIS public charge. There's all the information on public charge, and it even lays out the COVID related information. And you can even look at it now as I'm presenting, and you'll see that all the material comes from that website. It's very helpful. So the USCIS, United States Citizenship and Immigration Services, they determine the public charge ground by looking at a range of factors, and it's a totality of the circumstances analysis. It's not like, oh, the non-citizen applied for this one benefit, therefore they're totally disqualified. No, they look at a range of factors, including the non-citizen's age, their health, their family status, their assets, resources, financial status, education and skill level, the prospect of them getting their immigration status, and also, as in most cases, and I'm going to go over the public charge rule, maybe I should describe this first. Who does it apply to? It actually is pretty limited. So this public charge rule, for everyone to know, to tell people that you work with, it only applies to people, non-citizens, who are applying for legal permanent resident status. So whether they're already in the U.S. and a spouse, a U.S. citizen spouse, applies for their non-U.S. citizen spouse, husband or wife, to become a legal permanent resident, it applies to them. It applies to if you have a family member abroad in another country and they're going to come to the U.S. Embassy, the U.S. Embassy will do the analysis there about public charge. And it sometimes applies to people like on a non-immigrant visa, such as a student visa, and they want to get their residency, or they need to apply to a different non-immigrant visa, it might apply there. Their exemptions are huge. So a lot of the people we work with at Charlotte Center for Legal Advocacy is humanitarian-based relief. So refugees, asylees, special immigrant juvenile status, there's special visas for trafficking and domestic violence. None of those, public charge does not apply to any of those groups, and it also doesn't apply to anyone applying for citizenship. That's my dog. I'm sure you're familiar with many people on Zoom with animals. It doesn't apply to anyone who's applying for citizenship. We get that question a lot at CCLA. And if you have questions, I guess I'm not looking at the chat box, you can just put them there and I can respond in Spanish or English later. So I'm sure you're interested in what benefits are enumerated, what benefits this can affect. And I'm going to list them. This can be kind of dry and boring, but again, you can visit the uscis.gov website and it lists the specific benefits the rule applies to, those that it doesn't apply to. So any federal, state, local, or tribal cash assistance for income maintenance, that is included in the analysis. Supplemental security income, temporary assistance for needy families, TANF, federal, state, local cash benefit programs for income maintenance, any state ones it applies to, SNAP. For the most part, it applies to Medicaid. That's really has a lot to do with our presentation today. It applies to Section 8 housing assistance. Sorry for my dog in the background. It applies to Section 8 project-based rental assistance, which is important to know, and the housing under the Housing Act of 1937. And I wanted to stress that any cash benefit is considered even if the public benefit was only state funded, such as in North Carolina. It's also important to note that immigration does not consider any tax-related cash benefits, including earned income tax credit, any additional child tax credit, premium tax credit, any other tax credits do not apply, and we'll talk about that, how it deals with COVID. Other benefits that are not included, I'll just name a few briefly, such as short-term, non-cash, in-kind emergency disaster relief. One that comes up a lot with our clients who want to get a donation from a church, for instance, or go to a soup kitchen. So programs, services, or assistance such as soup kitchens, crisis counseling, such as if your client goes to the domestic violence shelter and they receive free counseling, that's not included. Short-term shelters, not included. And any assistance provided by local communities or through public or private nonprofit organizations such as churches is not included. So a lot of our undocumented clients do receive help that way, and it's important for them to know that won't be included later if they apply to become residents. Also, in relation to COVID, and I'll talk about that a little more specific, public health assistance for immunizations with respect to diseases and testing and treatment of symptoms of communicable diseases is not included. Another big one is attending public school. So all undocumented children can attend public school in the United States. And also any benefits. This is really important now during COVID. Any benefits through school lunch or supplemental nutrition programs, not included in this analysis. Another really important caveat that a lot of clients forget, if the parents are undocumented but they have U.S. citizen children, they can still apply for those benefits for their children, not for themselves, but for their children because they're U.S. citizens. A lot of our clients are hesitant on that, but I remind them it's for their child. In regards to COVID, so we get a couple calls about what if I go get a test for COVID treatment? Is that going to affect me? So USCIS has said that testing, treatment, any preventative care, including receiving a vaccine related to COVID-19, is not going to be part of the analysis for public charge. So the government is encouraging people, no matter their immigration status, if they have any symptoms of COVID, to continue to seek help. However, USCIS will still consider the receipt of any benefit during this period. So if you're applying for any other benefit, such as housing, that will be considered. In this situation, it's important to document why you had to apply for that relief, such as if you were laid off or you had a reduction in your hours at work. What you'll need to do when you do apply for residency, because again, public charge just affects people for the most part applying for their residency, they'll need to include a statement of why during the time of COVID they had to apply for some benefit, some public benefit, and also produce some physical documents, such as if you were laid off, if you have a letter, or your hours were reduced, show that your hours were reduced on paper, your pay stubs, for instance. You will have to submit that later on. Again, the Biden administration could get rid of this regulation at some point, but as we have it now, that's what they will need to do. Another question we get a lot is, will applying for unemployment insurance impact my client's immigration application? The answer to apply a loan for the unemployment insurance does not in itself, is not part of the analysis for public charge. Actually, the regulations do say that the Department of Homeland Security is not going to consider federal, state retirement, Social Security retirement benefits, post-secondary education, or any unemployment benefits as public benefits under this public charge and admissibility. And that's because it's considered to be an earned benefit. So for the most part, no, if you apply for unemployment insurance, that alone will not make you subject to the public charge. Another very important question we get, will receiving these stimulus checks from under the CARES Act, will that count against me as public charge? The answer to that is no. So the receipt of any stimulus funds for your family, if you're undocumented or you're a non-citizen, that is a tax credit. That will not count against you for the purposes of public charge. No tax credit. Tax credits are not public benefits. And another interesting, some information I found on the website that is very interesting and helpful for our clients with young children in school is that there's a pandemic electronic benefit transfer. So this is actually was set up as nutritional resources to families who've lost access to free or reduced price school meals. So again, any meals you're going to receive from school are not part of the public charge analysis. And that's just really important for our parents to know. One last thing I wanted to say is that the North Carolina Department of Social Services, they will check to make sure you're eligible for the program. They will check your immigration status, but they are not supposed to share any of that confidential information with ICE or any other immigration officials. So that was my part of what I wanted to present, but I'm hoping to get some questions. So I'm just going to read one. Let me see here. We see a lot of undocumented families declining or not applying for disaster relief services because of miscommunication or afraid to do so because of the public charge. Again, something you can always do is refer, if they're really afraid and want to talk to an immigration attorney, you can refer them to us just for a consultation to go over that. But if it is a public benefit, such as rental assistance, and I know Juan, maybe you can jump in and go over the first part of that affidavit showing you have to show that you applied for public benefits. They will need, if they apply for residency at some point, given public charge stays in effect, it will be good for them to document, why they applied for the benefit, which anyone who's going to be kicked out of their home or needs to pay their rent, it makes sense during a pandemic, but they will need to be able to document it and be prepared to have a written statement of their circumstances at the time and explain why they needed the benefit. You want to add to any of that, Juan?
So regarding like disaster relief, is that in regards to like hurricanes and issues that you guys see down east? Or is this just a general question about the disaster relief that relates to COVID?
Well, this is just a general question. I think this question comes up a lot within our communities and also with agencies provide services to the immigrant communities. So I think it's just a general question that often comes up all the time. So when we're dealing with any social issue with immigrant communities, public charge, since public charge was announced, it's always been an issue. So here I think we need to have two things. One is to educate more agencies that provide services to the immigrant community. And number two is to have more community events like these to educate the general public. You know, those are the two things I think.
Yeah.
Again, that's what they relate here. And just to give a little context about why we hosting this event today, we are one of the partners hosting the event today is because this information sometimes just go out to a specific groups. It doesn't go out to a large group that also provides services to the immigrant community. So the NC Latino COVID-19 Task Force, which was established in March for the state of North Carolina on behalf of over 100 individuals and groups come together to talk about this, was that's how we got here today.
Yes, I will definitely add that since the public charge, since we have that final rule, so many people in the immigrant community and the immigration attorney community have been very nervous and scared of it. Again, for the most part, it doesn't affect most people. It affects people applying for residency. And I did want to add that it is enumerated on the website that short-term non-cash in-kind emergency disaster relief is not a benefit, public benefit for public charge. I don't know if that is a direct response to that question. Also, it says on the website any emergency food assistance under the Emergency Food Assistance Act is not a public benefit, and any services under the Robert T. Stanford Disaster Relief and Emergency Assistance Act, haven't heard of that act myself, maybe you guys have, is not part of the public charge. A lot of the emergency relief, even with medical care, emergency medical care, normally as well is not a public charge, not part of the analysis.
Hi, Rebekah. This is Luciana Bria, and I was the one who posted that question because the main work that I do is in disaster relief. I worked as a disaster case manager during Hurricane Matthew, and I also did work for Hurricane Florence. And what I have been finding out in those communities, I walked some of those communities right after the impact. And the feedback that I was receiving from a lot of the Hispanic Latinx families, especially undocumented families, was that they were afraid to apply because they didn't want to hinder their opportunity to, in the future become a resident or legal citizen in this country. And so that's I would say that's one thing that it's sometimes very, very hard to communicate and convey to these communities that it's okay to apply for the services and that it's not going to impact them in the future. So your presentation is wonderful, and I was wondering if you or your group are able to provide presentations at different levels to different groups.
Yeah, no, I think that'd be great. And in my career, I've done a lot of presentations directly to the immigrant community in person. If it weren't for COVID, that was always best to gain their trust so they see me. I think and I've noticed with public charge especially, it's like taboo, it's scary, everyone's afraid. Even pregnant women now are afraid to get help when in any state in the United States, they can get Medicaid during their pregnancy and 60 days after. But a lot of immigrant community, they're just not aware of it, or they get mixed information on Telemundo, and they're doing their best, but they don't get always the correct information. So I think definitely that's something we can do. Of course, it'll be virtual, but it'd be nice to reach the immigrant community directly, and talk to them. And explain the public charge rule and who it applies to. And again, like I just did with you, it can be a little dry and boring, but to go through some of the benefits that are included and some that aren't. But of course, during this time with COVID and with the affidavit that Juan was talking about for the rental assistance, USCIS does say if you do have to apply for something, and you do later apply for your permanent residency, immigration will take it.
I think Rebekah.
Yeah, I think we lost Rebekah.
I think what Rebekah was going to say is that it is a totality of the circumstances analysis when it comes to the public charge rule. So when you're looking at if the tenant has to apply for emergency rental assistance, creating some sort of documentation as to they lost their job directly due to COVID, they got their job back after such and such time because COVID situation bettered, or they were able to get their job back after a certain amount of time. If they have those documents and they can show that later on, that's a clear explanation of it being a temporary loss of income that does not mean that they are long-term a risk to be a public charge to the country. I will also mention that Charlotte Center for Legal Advocacy has a specific public benefits group who recently have started working with people just in even applying for food stamps. If a family, let's say mother and father are undocumented, but children are U.S. citizens, the U.S. citizen children are the ones that are receiving the public benefit. It is not mom and dad. Because U.S. citizen children are receiving the benefit, that does not pose that public charge risk. And then in the context of, let's say, HUD housing. So in HUD, there was a rule that was going to get pushed that if there was a mixed status families, that entire family would no longer be able to be eligible to receive any funding through HUD for subsidies. The present rule would be that they would have a prorated amount. So that prorated amount rule is still in place. So that rule where mixed status families would be fully kicked out of receiving any HUD benefit, that did not go into effect, and that's something that some people that I've spoken to were concerned about. One other thing I want to point out is that for humanitarian relief, so if somebody's applying for asylum, refugee status, U visa, a VAWA claim, they are not subject to this public charge analysis. It's basically people who are applying for change of status based on a family petition. Is that right, Rebekah?
Yes, sorry, the power went out in my house. I've had a lot of problems today. Yes, so this only applies to people who are applying for legal permanent residency, whether they're already in the United States or they're abroad. And that's most likely through a family-based petition, a U.S. citizen, spouse, parent, or child applying for their spouse, parent, or child, or sibling, could be sibling too. That's the main. And that's just family-based. So there's other visas, as Juan was mentioning, asylum, U visas, all the humanitarian visas. Even when they go to adjust their status, this rule is not going to apply to them. So it's strictly, for the most part, family-based visas.
There is another question. I'm not sure if you, either of you have touched on. Someone said, I manage a TANF-funded contract for housing assistance. The checks are made to the property manager or landlord. Is this considered in kind since it's not cash to the tenant?
So that's a good question. I believe it will actually be considered a cash benefit, seeing as it's like essentially a cash payment where the tenant, they're just skipping the tenant. Instead of the tenant getting the cash and then paying the landlord, it's just going, it's a straight pipeline. So this is how a lot of the CARES Act money went and got paid out. Again, if somebody is facing homelessness and that's what they're facing, there is I encourage people to think about that, and there's a way that you can explain receiving a public benefit during COVID. You can create the documents that prove that, hey, this is a temporary loss of income. It was directly due to COVID. And you can actually, you can get those supporting documents in the future and prove that you are no longer a public charge issue. So now the question I see is it better to give funds to tenants? So is this, is it better to give funds directly to tenants? So let's say that you're a private organization. Yeah, I think that's fine. I would say, yeah, if you're a nonprofit, one of the things that I've seen is that if you want to make sure that the money goes to the landlord, and you're a private nonprofit, you can just directly pay the landlord. If you want to make sure that the money goes to rent. If you trust that your client is going to use that money and directly use it to rent, that's fine. So when I was looking at that question previously about money that's going directly to the landlord, it's the source of the money that's important. If it's a private nonprofit, there's no problem there because that's not included in the public charge rules. But if it's money coming from the state, and that money coming from the state is just being moved to somewhere, yeah. So if the money's coming from the state, then that's when the public charge comes into play. If it's just from a private nonprofit, there's no issue with that.
That's correct. Exactly.
The one thing I wanted to do before we get off, I would like to do just a quick what the CDC affidavit is in Spanish, if everybody's okay with that.
You had one more question in the chat. Somebody asked if you could provide your contact information.
Yes, thank you. I will do that right now. And then I'll also have, yes, perfect. And you can reach out to us. There's a specific, as I mentioned, there's a specific practice group within our law firm that handles public benefits, and they do a lot of presentations about how public charge impacts people.
And they're bilingual too. They speak Spanish and English, which is great.
Yeah. All right. So I am going to go ahead and start with the Spanish section. Entonces, presentemente hay un moratorio contra el desalojo por razón del gobierno federal y brevemente protege a personas de ser desalojadas por razón de no poder pagar la renta. Esta protección es hasta el fin de enero. Puede ser que las protecciones sean continuadas, pero eso depende de si el presidente Biden continúa esta protección. Es posible que la protección sea continuada, pero no es seguro hasta que ocurra. Para recibir esta protección, alguien tiene que, no es automático. La protección tiene que ser, tienen que hacer algo para recibir la protección. Para recibir la protección, tienen que entregarle personalmente la persona que está nombrada en el contrato. Esa persona tiene que personalmente entregarle una declaración al arrendador. Voy a poner en el chat un link a donde se puede encontrar el documento, la declaración. I put in the link to the CDC website where you can find the affidavit. If the affidavit is updated, that should still be the same website link. That when the CDC updated the affidavit, they did not change the web address, so I would expect that in a month, if they do update it, you can still click on it. La protección contra el desalojo solamente se relaciona a las personas que no pueden pagar la renta, Estas protecciones no son para personas que están en violación del contrato por otras razones. Por ejemplo, si alguien tiene a un perro que no está permitido bajo el contrato, esas personas todavía pueden ser desalojadas. Acuérdense que la única manera legal en este estado de desalojar a alguien es por las cortes. Entonces tienen que ir a la corte para ser desalojados. Un arrendador no puede llegar a la casa, cambiarle las chapas. Eso es ilegal. Un arrendador probablemente no puede pagarle la agua y para obligarlos de salir. Eso también es ilegal. Entonces, la única manera de ser desalojado ahorita siempre es por las cortes. Entonces, cuando alguien recibe documentos de la corte, es muy importante ir a corte, porque cuando el inquilino va a corte, obliga a que el arrendador pruebe su caso. Tiene que comprobar que legalmente es permitido hacer el desalojo. Ahora, esta declaración que se tiene que entregar, ¿qué es lo que dice? Ahora, esta es una declaración jurada, entonces lo que significa es que ustedes andan jurando que si se firma y se entrega a un arrendador, eso significa que ustedes andan diciendo que lo que dice ahí es correcto y que les aplica a ustedes. Entonces, ¿qué es lo que dice esto? La declaración jurada. Ahí nunca menciona que el estatus legal de alguien que tienen que verificar su estatus legal. Eso no está involucrado en ninguna manera. Lo que andan jurando, andan diciendo de que van a ganar menos de $99,000 o $198,000 si están casados y andan haciendo sus impuestos juntos con una pareja, que han hecho sus mejores esfuerzos para obtener asistencia del gobierno para pagar la renta. Y esto lo que significa es de que en los últimos meses el CARES Act nos dio dinero a la comunidad para directamente asistir con los pagos de renta. Ahorita aquí en Charlotte ese dinero ya se ha acabado, pero en otras áreas del estado puede ser de que ese dinero todavía está disponible. Si alguien anda tratando de someter este documento, es importante que ellos traten de obtener ese dinero. Ahora, ese dinero sería considerado como un pago directo del gobierno. Entonces, ahí es donde el cargo público puede ser considerado. Ahora, lo que es importante del cargo público es de que es una consideración en total. Una acción particular no va a causar a alguien que falle el examen de cargo público. Se pueden explicar las situaciones. Y ahorita lo que le ando diciendo a todos es de que con relación al cargo público pueden tratar de encontrar documentos para comprobar cuando andan aplicando para la residencia que en ese momento no son riesgos de ser un cargo público. ¿Y qué documentos en particular? Documentos que dicen que perdieron su trabajo solamente temporariamente por COVID, que alguien tuvo la enfermedad y que regresaron a trabajar después, y que por ese momentito necesitaban asistencia. Entonces, porque el cargo público considera todo, es una examinación completa, eso puede ser explicado. Entonces, si alguien está viendo que es posible que sean desalojados y no tengan un lugar donde vivir, es importante considerar usar esta asistencia que está disponible. Ahora, alguien preguntó si vamos a tener fondos nuevos para HOPE. Es posible, es probable. La nueva ronda de estímulo que pasó, todavía los legisladores en Raleigh no han decidido cómo dividir esos pagos. So someone asked if there's any movement on HOPE funding and whether that will come around to our clients. So the last batch of stimulus or COVID funding came out of the federal government recently. It has to be appropriated in Raleigh, so we'll have to figure out who gets what. And I'm hoping, and I would believe that HOPE would probably be one of the recipients of that. I'm not exactly sure how much money North Carolina received, but I think that sounds right. And I see 700 million. I think that's right, but you can't quote me on that. Otra calificación para usar la declaración jurada es de que la persona no puede pagar la renta porque le reducieron las horas, fueron despedidos o tuvieron gastos de médicos grandes. Eso significa 7.5% de lo que ganan cada año. Entonces, esto no significa que esos gastos médicos tienen que ser directamente por razón de COVID, pueden ser por otras razones. Si alguien tiene cáncer, si alguien tiene diabetes, eso puede ser considerado en los 7.5% de gastos médicos. Otra cosa que andarían jurando sería que si son desalojados, no tendrían un lugar donde vivir, o tendrían que ir a un albergue, o tendrían que moverse con alguien, y va a haber mucha gente en unos lugares cerrados. ¿Qué más involucra este documento? Este documento no anda perdonando la deuda. So this document does not forgive any debt. It also...
Una pregunta.
Sí.
Cuando uno renta y si se le descompone algo así de la casa, una ventana o como lo de la casa, la luz y eso, ¿uno tiene que pagarle al rentero o de lo que uno paga de renta él lo pone?
Entonces, parte de la respuesta de eso es basado en lo que dice el contrato. So I was asked if how do expenses, if you're renting a property, who's responsible for paying the repairs? So it depends on the contract. It depends on the cause of the problem. Something that I tell all my tenants is North Carolina statutes specifically say that requests for repairs have to be made in writing unless they are in an emergency and relate to a serious habitability concern. So it's very important that if you're asking as a tenant to have your landlord repair something, that you have it in writing. Señora, otra cosa que le diría es, si usted quiere que su arrendador le arregle algo, por ley estatal, el arrendador puede obligarle a usted que le entregue algo en escrito pidiéndole que haga el arreglo el arrendador. Notificación verbal no es necesariamente suficiente. Puede ser que el arrendador acepte notificación verbal, pero es mejor tener algo en escrito.
Porque lo que pasa que yo aquí donde yo rento, a mí me cobran por arreglarme las cosas.
Okay, entonces, su situación es particular. Entonces, lo que voy a hacer es voy a dejar ahí mi información. ¿Y en dónde vive usted?
En Wilson, Norte Carolina.
¿En Wilson? Ok. Voy a tratar de ver si, no estoy seguro su situación, pero podemos hablar en el futuro sobre eso. Ok. La última cosa que les voy a decir es de que si alguien recibe los papeles de corte, es muy importante ir a corte. Ustedes podrían haber sometido el documento de protección, pero puede ser de que el arrendador todavía continúe a llevarlos a corte. Si reciben papeles de la corte, tienen que ir a corte y traten de tener una prueba de que ustedes entregaron ese documento. Entonces, cuando entreguen el documento, traten de tener 2 copias, una para ustedes y una para darle al arrendador, y quédense con esa copia, porque si van a corte y esta protección está continuada, ustedes pueden enseñarle ese documento al juez y por ley ustedes no deben de ser desalojados. So I gave a very quick overview of the CDC declaration in Spanish. What I'm going to do is I'm going to leave my information in the chat, and people are more than welcome to reach out to me. I know it's 2 o'clock, so people are more than willing. I'm more than able to talk to people, and we can go from there.
Yeah, and I'm free to talk to people if they want to know more about public charge, or if they want to refer someone to us who is worried about it, because I know many immigrants aren't applying for certain benefits because they're afraid of public charge. Even immigrants with U.S. citizen children aren't applying for benefits for their children, which is really sad. And we want to make sure that those people understand the law and their rights.
Yeah. So thank you so much, Juan and Rebekah, for this valuable information. We really appreciate it. And we are hoping that everybody valued the expertise that you brought here and the conversations that you've shared with us today. I hope that these conversations continue. And I think Hovencio is right, is we got to have them more often and get them out into the community. And so what we plan to do at Disability Rights is to any updates that we have, we would definitely put it on our website. So feel free to go to our website. Feel free to contact us as well. And Erica, if you can put Disability Rights contact information in the chat, that would be great as well. We appreciate you. We thank you for the chat. I think it was a meaningful discussion today. And we look forward to the continued conversations, and we look forward to continue to partner with you to get this information into the communities. Are there any last questions? But thank you so much. Thank you, Juan and Rebekah. We really appreciate it. Thank you, thank you, thank you.
Thank you,
Thanks for
Arshil. Have a
having
good
us.
one.
Okay. Bye-bye, everyone.
Thanks, Iris. This was awesome.
Thank
great.
you.